President, please be seated. The court is now back in session. We would like to hand over to counsel for Mr. Nuntia to continue his presentation and observation regarding the key documents put by the co-prosecutors and the lead co-lawyers for the civil parties. You may now proceed.
Thank you, Mr. President. Good afternoon, Your Honours. Good afternoon, Council. I will continue with my comments on the probative value of the documents presented in respect of the targeting of the Lon Nol officials and military. And I had arrived before the lunch break at the revolutionary flag from August 1977, document number E3/193. The prosecution claimed during its presentation that this document contains an instruction to execute Lon Nol soldiers in positions of authority in cooperatives. First, Mr. President, we would like to ask the Chamber to notice that this particular document is dated 2.5 years after the events at Tulpo Tre. So, in our view, it is entirely irrelevant to state policy as it existed in April 1975. The substance of the document, in any case, contains only vague ideology. It has no instruction or order to cause harm to anyone. Now, the co-prosecutors may have succeeded in giving the Chamber a different impression during their presentations, but they did that only through duplicity. By, as it were, stringing together into one coherent paragraph 3 unrelated excerpts from 3 different pages. They took one in passing reference to Lon Nol soldiers out of context. They placed it next to a second out-of-context instruction 4 pages later to, quote, smash the enemy. And then they invited the Chamber to conclude that cadres were being instructed to smash Lon Nol soldiers. A closer review of the document shows something much more benign. At ERN English 00399-234 until 35, Khmer 0062963-4, and French 00611-839-40, the reference to Lon Nol soldier is merely an example of the non-peasant class in positions of authority in certain cooperatives. To them, the reference is made. The instruction to smash on page 17 was not an instruction to kill people, but to eliminate ideology. And a fuller quote from that section of the document reveals that, and I quote again, and this is a lot longer citation, who holds the power in each cooperative? Generally speaking, in the entire West Zone, in a large part, we already control the cooperatives and state power, meaning it is already in the hands of the party's worker peasants. It is still in the hands of various other classes. And if it is in the hands of other classes, have those classes come over to the side of the revolution? No, they oppose the revolution. It is only a matter of whether they oppose the revolution a little or a lot, whether they antagonistically oppose or do not yet antagonistically oppose. After we make this assessment, we have to prepare to lead the cooperatives. Prepare what forces? Prepare the poor peasants and the lower middle class peasants to control the cooperatives, to attack and smash the state power of other classes who stole control from of our cooperatives, and give it back to the poor peasants and the lower middle class peasants down below. Now we have been able to screen and fight in the zone, able to fight in the sectors, able to fight in the districts. But we have not yet been able to fight in the cooperatives. It is imperative to prepare forces to attack and smash the enemy and the no-good elements embedded inside and controlling the cooperatives. End of quote. We would like to ask the Chamber to recognize two things about this larger quote. One is that the so-called other classes in control of the cooperatives do not necessarily, I quote, antagonistically oppose the revolution. And the second is the instruction to, quote, smash the state power of other classes and then give that power, quote, back to the poor peasants and the lower middle class peasants down below. Now, no policy to execute former soldiers could possibly be inferred from this document. Mr. President, the final four documents in the presentation of the prosecution all purport to be military communications from either the north or northwest zones and addressed to either Committee 870, Ankar, or Brother Paul. The four documents are similar. They all report that enemies have been recently identified and state that some of them are former Lon soldiers. One document states that they were arrested, and two do not say what action, if any, was taken. The last telegram states that the soldiers were purged. As we have seen, that term can have different meanings. So these final four documents are literally the only four key documents presented by the co-prosecutors, which suggest that anyone in the party center was even aware that any action of any kind was taken against former Khmer Republic officials beyond the 7 super traitors. None of these documents say that the soldiers were killed. None of the documents describe any action taken by the party center. And all of the documents are dated long after the events at Tu Po Tre took place. So they are not in any way probative of a policy to execute all Khmer Republic soldiers and officials as of April 1975. Mr. President, Your Honours, that concludes our discussion of the prosecution's statements, the prosecution's documents. We will now turn to the final segment of our response with regard to this alleged policy. We will present documents, certain witness statements tendered into evidence by the co-prosecutors. Now, those statements will establish two things. First, the witnesses who are best placed to know about the intentions of the party center and the conduct of troops and cadres on the ground consistently testify that Lone Nol soldiers and officials were unharmed. Second, the evidence which the prosecution contends establish a pattern of executions is systematically unreliable, especially in the light of the direct evidence which contradicts it. Mr. President, with your leave, the first document we would like to present is an excerpt from a video. The video is One Day at Portray. You have seen portions from that video earlier. The document number is E1861R. The relevant passage in that video is from the timer at 21 minutes up until 22 minutes and 3 seconds. And in it, Nguyen Cheas states his position about whether a policy to execute former Lone Nol soldiers existed. So with your leave, Mr. President, I would like to show the chamber this minute from the To Portray movie.
The President, Mr. Co-Prosecutor, you may now proceed.
Thank you, Mr. President. Notwithstanding that this video is not on the list of presentation documents that we were provided with, we have no objection to it. I assume, however, that counsel will be playing the full excerpt, given his repeated ad hominem attacks on the prosecution today. I would hope that he is playing the full excerpt of what Nguyen Cheas said on this tape, including the part where he admits to the execution of the top officials of the Lone Nol regime. But assuming that counsel is playing the full excerpt of this video, we have no objection, notwithstanding it not having been listed.
I was intending to particularly show the passage in which he says that there was no such policy. I do agree with the prosecution that the video goes a little further, and I have no problem in showing that as well. So that would be then, Mr. President, an instruction to the AV unit to show, I think, 20 or 30 seconds more than now to you anticipated.
The President, indeed, counsel, you may proceed. As requested to have this portion of the video footage be put up on the screen, and as the co-prosecutor already requested that the showing of the video should be longer than what has been requested. With that, the chamber also agrees that this extra portion should also be put up on display. This means the video length would be now 30 or 40 seconds longer. Now, every booth is advised to put up this document on the screens.
Ini semua kecilចំណុចនេះមួយទៀតទៅនឹងខ្ញុំសួរក៏មុនម្ដងហើយប៉ុន្តែចង់បញ្ជាក់ដាក់នៅក្នុងនេះតិចន័យថាទាក់ទិននឹងទៅហ៊ានលន់ណុលបាទកាលដែលរំដោះឆ្នាំថ្ងៃ17មេសា75បាទតើមានគោលនយោបាយយ៉ាងណាខ្លះចំពោះទាហានលន់ណុលហើយឬមួយក៏មាននយោបាយទៅដោះស្រាយទៅពូពី3នាក់ខាងលើតើមានអ្នកណាខ្លះឬយ៉ាងម៉េចបាទព្រោះថាពេលក្រោយដល់រំដោះមកវាមានការដែលយកទាហានទៅសម្រាប់អីចឹងបាទសូមអ៊ំជួយដោះស្រាយតើបញ្ហាហ្នឹងយ៉ាងណាបាទតាមអ៊ំជ្រាបមកបាទ
តាមខ្ញុំដឹងណាមេគីចំពោះទាហាននេះចាញ់មួយដាក់អាវុធគេដាក់អាវុធហើយណាបើទីបញ្ជូនគេទៅស្រុកគេទៅផ្ទះគេនៅណាឲ្យគេទៅហ្នឹងអានេះតាមចាំប្រតិបត្តិយ៉ាងម៉េចយើងមិនដឹងទេ
អ៊ំបញ្ជាក់មេគីនយោបាយចំពោះអ្នកទាំងប្រមាណ 3-4 នាក់ហ្នឹង 4-5 នាក់ហ្នឹងយ៉ាងម៉េចបាទគោលនយោបាយបាទ
គោលនយោបាយគឺកំតិចនិយាយពាក្យងាយកំតិចពួកនេះវាຕົកធ្ងន់ណាលោកប្រទេសជាតិគឺបរិវារគឺអានេះមានប៉ុណ្ណឹង
ចុះក្រោយមកអ៊ំមានបានលើគឺជំរាបទាក់ទិនទៅរឿងបញ្ហាដូចជាការក្រោយពីថ្ងៃ17មេសា3-5ថ្ងៃបាទមានការដោះស្រាយទាហានពីច្រើនពាន់នាក់ដូច
Mr. President, I would like to remind the Chamber that the prosecution seems to think that Nguyen Chia was fairly honest in this. Something.
The President, every booth is now instructed to play this videotape again and to include this additional portion of the episode, perhaps 30 to 40 extra seconds.
Nó phổ sát bắt bò bay lên bản tin miền Tây ta bành hà đi ông miền bàn chỉ tí tí nục mà
ពេលនេះខ្ញុំមិនដឹងទេគឺការដោះស្រាយអីផ្សេងៗណាមិនបានដឹងសល់សោះមែនខ្ញុំដឹងខ្លះទៅពេលដែលធ្វើសមាហរណកម្មនេះហើយបានដឹងយ៉ាងមិនខ្លះតិចតួចគេឲ្យនិយាយគេឲ្យដឹងណាពេលកាន់ណាអត់ដឹងហើយបើដឹងកាលដឹងថាមានបញ្ហានេះយ៉ាងមិនក៏ត្រូវមានវិធានការទប់ទល់ដែរកុំឲ្យមានអញ្ចឹងណាវិធានការទប់ពីព្រោះគ្នាអស់នេះគ្នាគ្មានទោសកំហុសទេជាកូនតាហ៊ានធម្មតានោះហើយជានិយាយរួមដូចជាប្រជាជនធម្មតាអញ្ចឹង
Mr. President, Your Honors, I was saying that I would like to remind the Chamber that the prosecution seems to think that Nguyen Chia was fairly honest in this video. Prosecutors have introduced a series of his statements which they say are incriminating. And in this clip, with respect to this particular policy, Nguyen Chia denies that the policy existed. And he said that, in the view of the prosecution, to someone he trusted. And he never thought that this statement was going to be public. So we think that his statement in which he is denying such a policy existed is trustworthy. And it is also corroborated by the statements of other witnesses, as we will see in a moment. The next document we intend to present, Mr. President, is number E3/1593. That is at English 00678-523 and at Khmer 00637444 until 45. There's no French version of it. It's Ben Keenan's book, The Pol Pot Regime, Race, Power and Genocide in Cambodia under the Khmer Rouge. And at that page, in that book, Keenan describes a meeting which allegedly took place on 20 May 1975. And the passage in that book reads as follows. Heng Samrin, then studying military affairs under Son Sen, was also at the meeting. He recalls the use of another term. They did not say kill, they said scatter the people of the old government. Scatter, komchat, scatter them away. Don't allow them to remain in the framework. It does not mean smash, komtek. Smash means kill, but they use a general word, scatter. Nguyen Chia used this phrase. End of quote from this book of Ben Keenan. And I would just like to point out that this seems to be a more reliable excerpt than the one in Keenan's book about Numuk, which I tried to say earlier, but I was objected to, was unreliable. Because in the Numuk excerpt, Keenan actually draws a conclusion on the basis of what his source told him. And here, with respect to this particular passage, he is merely relaying something told to him by somebody else. Mr. President, the next document I would like to present is actually a motion that we, the Nguyen Chia defense, filed in February of this year. The document is E236/5/1, and the language I would like to quote is at paragraph 3, and it states, Nguyen Chia's relationship with TCW 223 dates to before the Geneva Conference, some 60 years ago.
The President, Mr. Co-Prosecutor, you may now proceed.
Mr. President, this is another document I didn't see on the list, and if I just heard right, it sounded to the prosecution like counsel is reading from one of his own filings. Again, reading from your own filings is not presenting documentary evidence, so we would object to counsel's doing that if indeed I understood correctly as to what this document is.
Of course, Mr. President, we try to figure out the exact parameters of this proceedings. We are allowed to present our own key documents. I'm not quite sure where the limits are between possible evidence or quoting from your own work, so to speak. So, unless, of course, there's a ruling from your side that we are not allowed to quote from motions, then we would like to cite from this document and consider it to be a key document.
The President, objection by the co-prosecutor against the exercise of rights by the defense team on observing on the document presentation is appropriate. Therefore, the defense team is directed not to quote a portion of your documents to present. The Chamber has already advised you already that you are here to respond to the various key documents presented by co-prosecutors and lead co-lawyers for the civil party presented from the 24th to the 27th of June. And the defense team has also made it clear to the Chamber that you do not have any proposed key documents to present, but you want to reserve your right to respond to the various key documents submitted by other parties, and you may also raise some objection against those documents.
Thank you, Mr. President. We will move on. The next document I would like to present, and I'm not quite sure if I'm now prohibited from presenting other documents. It is not from our own work, which is always nicely quoting, but
the President, you may make additional observations on the key documents presented by other parties, but you are not allowed to extract any portion of documents to make a presentation now, because you are supposed to comment or make any observation on the key documents presented by co-prosecutor and lead co-lawyers for the civil parties from the 24th to the 27th of June 2013.
I understand, Mr. President. We have understood it in such a way that although we initially didn't say that we would be allowed to present our own key documents. It sort of came about this last 2 days. So if you do not want me to quote from some documents which we consider key documents, that is fine. Then let me just have a quick look if the rest of the things that I would have wanted to say in respect of the policy is
the President. Judge Sylvia Cartwright, you may proceed.
Thank you, President. I'm sure you do understand, Mr. Kopi, the President's ruling and the Chamber's ruling is that you may not quote as key documents your own submissions, your own applications, but of course the Chamber welcomes your comment on any documents that have been put before the Chamber and are, of course, on the case file. And that is the purpose of this segment of your address before the court today. So you can continue with key documents in the classic sense of that term, documents that have been put before the Chamber and are, of course, on the case file. Thank you.
Thank you, Judge Cartwright. Then allow me, Mr. President, to continue with a document which I would like to present. And that is a document, it's from an OCIJ statement of a witness who has appeared before this chamber. That witness is Rochum Ton, alias P. Pron, and the document number is E3/24. The excerpt is at ERN English 00223 582 and the Khmer version 00204069. I apologize, Judge Laverne, because I don't see why I don't have a French ERN number. I will provide that later. Now, the question put to the witness, Mr. President, is whether there were orders to seek out Lon Nol soldiers. And the answer of Pipon is as follows. No, because they had raised white flags already. There were clear instructions not to touch them. During war, on the battlefield, that was different. Now they had surrendered to us, and we need not touch them. Just welcome them and greet them, and respond to the questions which they asked us. He said that they were Cambodians, like us. Don't touch them at all. Those were the words of Pol Pot. And if you allow me just a quick additional comment about the witness testimony as well. The Chamber will remember that when Philip Shore testified before the Chamber, he testified that the existence of a policy of executing Lon Nol soldiers was, I quote, a fact. And after we have examined him extensively, he was able to identify only one source who had ever told him firsthand that he was personally aware of the execution of Lon Nol soldiers. And who was that one source? Pipon. There are several other witnesses, Mr. President, I could quote, but I will settle on just one more. And I'm quoting this one witness just to give the Chamber one example of soldiers who were fighting on the ground and who say similar things about the orders they received. It is a transcript. I hope you will allow me. Transcript dated 25 October 2012. I see already the prosecution standing. I will move on, Mr. President. What I would like to do now, Mr. President, Your Honours, is talk about the statements that the co-prosecutors presented. The co-prosecutors read from 3 statements in court. When they finished, they said, and I quote, "There are many witness statements I could read from. Those have been identified in our filing of relevant witness statements to this policy." End of quote. I point that out to the Chamber because it's been clear to us for a while that this is the essence of the prosecution's case. The direct evidence of a policy is non-existent. So it seems that they are now trying to drown the Chamber in statements suggesting that executions happened in order to manufacture an impression that this practice was so widespread that it must have happened pursuant to a policy. I also remind the bench that when Philip Short testified, that was essentially his argument. He was positive that a policy existed, he called it a fact, but when he was pressed on it, his only real evidence was that it happened everywhere. I'm bringing that up right now to explain the remarks I'm about to give. And in order to properly respond to what the co-prosecutors have said during their presentation of key documents, I need to make some general submissions about the witness statements which are on record. Because the position of the prosecution is fundamentally that, and I quote again, "There are many witness statements showing this policy." Now, we have done our own analysis of the statements allegedly relevant to this policy. And we have looked at statements cited in 2 places. First, we looked at the statements cited by the OCIJs in connection with certain proposition in the closing order. And we've looked through the co-prosecutors and the civil parties lists of statements and complaints tendered for admission. And we have identified a little over 100 statements that the OCIJs, co-prosecutors and lead co-lawyers altogether say are relevant to the existence of a policy of targeting soldiers and officials of the Khmer Republic. Now, Mr. President, I know that sounds like a lot, 100. And to be honest, I can understand why the prosecution took the position as they did in their key document presentation. But this is, of course, why we have a trial, to test that evidence. And when you look at these statements carefully, soberly, objectively, what you find is systematic and serious flaws in all of these 100 statements. As I said, we have read and catalogued those statements in detail. Obviously, it is impossible today to present these 100 statements here systematically. We simply do not have the time for that. But I can tell the Chamber that in not a single one of those 100 witness statements, not one, does a witness claim to have personally seen a single execution. We would submit that in light of the prosecutor's claim that a center-driven policy required the execution of all Lon Nol soldiers and officials across the country, that is an extraordinary fact. And by itself, it makes the prosecution's claim during its presentation of key documents extremely unlikely. Now, if these witnesses in their 100 statements did not actually see executions, what is it that their statements say? They say a variety of things. Some witnesses say that they saw soldiers or officials from the Khmer Republic separated from larger groups, but do not know what later happened to those people. We have already said today why we think that kind of evidence is unreliable, does not have any probative value. Other witnesses say that they saw dead bodies of soldiers on the side of the road in or around Phnom Penh shortly after 17 April 1975. Now, because the soldiers of that army had just been defeated in a war, the fact that dead bodies were on the ground is probative of literally nothing. Also, that evidence in those 100 statements should be disregarded. Numerous statements of these 100 statements, including the majority of the victim complaints, merely state the bare fact that friends or relatives who were part of the Lon Nol regime were killed. In most cases, there is no reason at all to believe that those people were killed because they were Lon Nol soldiers. The 3 statements described by the co-prosecutors in their presentations are all vulnerable to these criticisms. The first, D25/28, concerned the Krang Da Cham prison connected to the Tram cooperatives. The witness in that statement claims to know, and I quote, "When they arrived there, they had them make biographies, and anyone whose biography said they had been a soldier would disappear. But the statement, however, shows at English ERN 00223475 that the witness had no role at Krai Dai Cham prison. He went there once to inspect a, quote, disturbance because someone had allegedly been raped. He could not have any personal knowledge about what happened at the prison." The witness in the second statement, D232/44, told the investigating judges only that, as far as I know, evacuees were taken for execution. He then said that those who indicated that they were Lon Nol soldiers when they first arrived, quote, later on disappeared. He also suggested that many other people were killed, but he offers no first-hand knowledge of what happened to any of them after they, quote unquote, disappeared. And the witness in the third statement, D125/91, stated that he, and I quote, saw them walking hundreds of people to be killed, unquote. He does not claim, however, to have seen them get killed. There is no indication in the statement about how he knows they were killed. And it seems that the investigators did not bother to ask him. I'll ask Mr. President, the Chamber to recall that these are the 3 statements the prosecution chose to best exemplify their evidence that former soldiers and officials of the Khmer Republic were systematically executed. And that kind of evidence has consistently fallen apart during cross-examination, as we have seen last week during the examinations of Pech Chim and Lev Lam. I will not discuss the evidence given by those 2 witnesses. You were all there present, so you remember, I'm sure. But it is obvious that once cross-examined, no witness stands at the end of the cross-examination.
The President, Counsel, please hold on. Mr. Prosecutor, you may proceed.
Thank you, Mr. President. I wanted to give Counsel a chance to do this presentation, and we certainly have no objection to him making comments about the value of the 3 statements. I do object to his attempt right now to make submissions and arguments about the credibility of witnesses who have testified in this trial. And I would also object to his prior attempt to testify himself about the content of the other statements. His assertion that none of these statements evidence executions of Lon Nol soldiers is simply incorrect. It is not time for closing arguments. counsel is not a witness. He certainly can present the witness statements that he wants to present. He's entitled to comment on the statements we presented, but he's not here to provide his own summary of the evidence or his own arguments about the evidence. And I would object to his characterization or attempts to make arguments about the testimony of the witnesses that he's referring to right now.
Mr. President, I will move on. I have one or two more things to say about the policy of targeting former Lonol officials and soldiers, and then I will be finishing my submissions or my reactions to the key documents. And my last remark is the following, Mr. President, Your Honours. It would seem that from a statement that you, Mr. President, made in passing during the trial management meeting on June 13, that the Chamber is likely on the verge of omitting every one of these statements that I just mentioned. If that is true, our position remains that that decision would be based on a serious misreading of the applicable law. It would also be a violation of Nguyen Chia's right to a fair trial. But if the statements are to be admitted, it is essential that the Chamber bear in mind its decision of 20 June 2012. That decision is at E96/7. And in it, the Chamber held that if statements are admitted without cross-examination, they would be afforded little or no probative value. And for all of the reasons I have just discussed today, these statements we have been discussing are especially unreliable and have no probative value whatsoever. And so that holding needs to be taken seriously, Mr. President. Even if we were to disregard all of the problems with the reliability, the probative value of these statements and accept them at face value, they would still fail to establish that the CPK established a policy of executing former soldiers and officials of the Khmer Republic. That is because almost all of that evidence in those statements of any kind concerns events in either the Northwest or the Southwest zone. If CPK policy existed, the evidence would show executions across the country. Yet, the witness statements, the evidence, the documents of executions in 5 of the 7 zones of Democratic Kampuchea is virtually non-existent. Obviously, Mr. President, Your Honours, unfortunately, we cannot make this showing systematically here today. But we invite the Chamber to observe that all 3 witnesses, the co-prosecutors, sought at the June 13 trial management meeting were from either the Southwest or Northwest zone. All 3 witness statements the co-prosecutor presented on June 26 were from the Southwest or Northwest zone. And the closing order itself concedes at paragraph 209 that officials were targeted, quote, in particular in the Northwest and Southwest zone. And our analysis, and this is my last words, Mr. President, shows that this bias permeates all of the evidence. And we'll make that showing with greater specificity in our closing briefs. That is rounding up, Mr. President, my submissions, our reactions to the presentation of key documents in respect of the enemy policy, the enemy targeting policy. Now I would like to turn to our response to the presentation of the prosecution and the civil parties on forced marriage. To begin, I would like to refer the Chamber to the closing order. As the Chamber is aware, the title of this policy in the closing order is the regulation of marriage. but the underlying facts it alleges are much more precise. Paragraph 216 states, 216 of the closing order, the CPK forced couples to marry as it took control progressively over parts of Cambodian territory before 1975 and continued to do so until at least 6 January 1979. Paragraph 218 states, and I quote, there is evidence that the CPK forced people to marry as early as 1974. End of quote. And other allegations in the closing order are similar. Now, the question, Mr. President, in this document presentation hearing is therefore whether the Communist Party of Cambodia adopted a policy of forcing people to marry each other. And like the closing order, the prosecution's presentation alleges that couples were forced to marry because that policy furthered the goals of the revolution. Now, we would like the Chamber to ask itself a simple question. If forced marriage was a core tenet of the revolution adopted for the purpose of furthering objectives that the revolution deemed important, would we not expect to see that policy advertised loudly by the party? The question is, was the Communist Party of Cambodia shy about the goals it thought were important? Did it not explicitly say, for instance, that people should leave the city and live in the cooperatives in the countryside? Yet, there is only one consistency in the documents presented by the co-prosecutors. They don't say the first thing about forced marriage. And many of these documents which were presented say nothing about marriage at all. The prosecution is asking this chamber to join it on a journey of convoluted logic. The prosecution wants the chamber to decide, one, the CPK had objectives like increasing population that might vaguely be related to a policy of forced marriages. And two, forced marriages allegedly happened. Therefore, the prosecution wants this chamber to hold forced marriage must have been a policy of the CPK. Now, obviously, that would be inadequate even if forced marriage were within the scope of this trial. But it is not within the scope of this trial, which means that all the supposed evidence that forced marriages took place is at this stage inadmissible. It also means that what the co-prosecutors are left with is vague political theory. What we would like to do, Your Honours, is to go through the documents that were presented in relation to this alleged policy and to show the Chamber that our characterization of the key documents as evidence is accurate. The prosecution began its presentation on forced marriage with a set of documents that they believe concern one of the ultimate objectives of the regime, population growth. These reports and interviews, including an issue of Revolutionary Flag, document E3/25, a speech by Ing Sari, document E3 1586, and an interview with Nguyen Chia, document E3686. These documents are believed to describe the CPK's plan to increase the Cambodian population to 15 or 20 million people in the years following the liberation. Now, if we understand correctly in the prosecution's mind, in order to achieve this population growth, the CPK insisted in forced marriages of Cambodian citizens. Now, even assuming for argument's sake that a plan to increase population existed, when you read those documents, there is no mention of forced marriage in any of these documents. Indeed, the documents propose an entirely different and frankly much more logical way of increasing the population, namely raising the living standard and health of ordinary Cambodians across the country. Take, for instance, document E3/25. That is an issue of revolutionary flag from December 1976 till January 1977. The prosecution quoted from that document the following passage. That was at ERN 00491435. We need from 15 to 20 million people to meet the needs of our land. For our population to constantly increase, the livelihood of the people must rise, and they must be in good health. So then this means quickly increasing production. End of quote. Document number E3/1586, the speech by Ing Sari, which the prosecution claims is particularly relevant, says at ERN 00798815 something similar. We are endeavoring very rapidly to improve the living conditions and health of our people because we need a population of 15 and 20 million in 10 years' time. End of quote. So these documents have no probative value whatsoever. They are all irrelevant. They suggest only the existence of a general political goal. There is no logical or empirical reason why that goal would be served by forcing people to marry each other. And the documents themselves explicitly give a different and much more comprehensible method of achieving that goal. So these documents presented by the prosecution should all be disregarded. The prosecution then moved on to documents that purportedly detail the CPK concept of marriage and family. The prosecution submitted during the documents hearing that the regime believed that the traditional concept of family was superseded by the revolutionary family, and that caring for an individual's family above the socialist movement was a betrayal. Once again, the prosecution is trying to turn water into wine. In other words, to find in the vaguest political theory a specific policy to force people to enter into marriages. One issue of revolutionary youth from October 1976 is typical of the documents presented by the prosecution. And the document number is E3/10, and the quote is from ERN 00450539. Mr. President, I apologize. You must have observed that I'm only quoting the English ERN numbers. We will present them to you at a later stage. But the document number, E3/10, in it states as follows, and I quote, "Private property, other manifestations, private ownership in organization by one's personal sentiments, by one's family, by one's clique, and notwithstanding the political ideology and the organizational line of the party is wrong. For example, anyone who thinks a lot about family interests interest always deceives the revolution and lives separately, seeking family happiness, not seeking happiness inside the party. End of quote. Another document presented by the prosecution, E3/750, is also an issue of revolutionary youth from November 1975. And at ERN 005224661, the article states as follows, and I quote, "In our revolutionary rank, our revolutionary male and female combatants and cadres sacrifice the private possessions such as housing, petty farm, garden, family, parents, relatives, children, and other properties in order to serve the party, revolution, and the people." As we hope is surely apparent, Mr. President, there is no mention of forced marriage in any of these documents. So it is our submissions that these documents have no probative value and are irrelevant. Another document cited by the prosecution is again an issue of revolutionary youth, document E3/766. And again I will quote, this time from ERN 005244181. The magazine relays a parable, I'm not quite sure how to pronounce it, about a 15-year-old boy. And it states, and I quote, "I have no parents or siblings. I am the child of the Communist Party of Cambodia. My parents and my siblings were killed and smashed by the Yuan enemy during the invasion of 1976. The villagers, my house, my rice paddies were destroyed and plundered by the Yuan enemy and taken back to their country. Now I am living in a new family. My parents are none other than the Communist Party of Cambodia, and I will now strive to do my best." End of quote. First of all, Mr. President, yet again, this document says nothing about forced marriage. In fact, it says nothing of marriage at all. So we submit it can be disregarded for that reason alone. It has no probative value. But we will add that even the message that the prosecution wants to draw from it is a poor interpretation of the document itself. We suppose that the prosecution thinks this document shows that the CPK was encouraging people to think of the party as their only family. But we submit that the only reasonable inference to make from this story is that it represents the CPK telling its citizens that it will protect them in their time of need. Now, if it were intended as propaganda in favor of the eradication of the family, it would exalt the fact that the boy has no parents. The boy wouldn't want to have parents. He would want to be with Ankar. But here in this story, the boy is alone only because parents were killed by the Vietnamese, allegedly the CPK's arch nemesis. We submit that if the party were trying to convey that the eradication of the family were a good thing, then the very last story that they would tell is of a family destroyed by the Vietnamese. Mr. President, I'm mindful of the time. I'm moving on to another document. Maybe, with your leave, this would be a good moment to break.
The President. Thank you, Counsel. Yes, indeed, it is now appropriate moment for adjournment. The Chamber will adjourn until 3 o'clock.
សូមក្រោកឈរ